Good afternoon and welcome to the third and final of our webinars on GDPR, where we look to unpick some of the key challenges to help you navigate one of the biggest developments in data-driven marketing since the dawn of the big data age. Today we will delve deep into the challenges around third-party data, privacy notices and the essential things you need to do in the final weeks before the 25th of May deadline. However, we are not slaves just to those subjects, so if you want to challenge, contribute, or even ask any GDPR-related questions of your own, please feel free to by clicking on the Questions tab on your screen at any point throughout this webinar. My name is Russell Parsons, and I'm the editor of Marketing Week, and I am your moderator today. You'll be pleased to hear, though, that I'm not tackling this alone. I am joined by two GDPR experts. We've got Fidel McGood, who is a director in PwC's Protection Strategy, Law and Compliance Practice and a former director of Information Policy and Strategy at Barclays, and John Mitchison, who's the director of Policy and Compliance at the DMA. Both have had GDPR on their mind for a good few years, and both will share their expertise with you all today. Afternoon, guys. Welcome.
Good afternoon.
Good afternoon.
Let's start, as I said, with third-party data. Given most of the third-party data is obtained without explicit consent at the moment, and that GDPR is pretty much dominated by the requirement of consent, how many people are going to agree to someone passing on their data? I suppose, to put it another way, does this spell the end for third-party data, John?
I don't think it spells the end of third-party data, but it does put some more restrictions on third-party data.
Okay.
I think in the past people have collected third-party data with consent, or at least that's the legal ground that they've given in the past. It's just that that's been a lot broader, and you've been giving consent to have your data passed on to general third parties, and that's been closed right down.
Fidel, what's your take? It's the beginning of the end, or?
I think it's the beginning of a change, definitely,
Okay.
and quite a significant change. And for me, I think there's implications both for the third parties that currently gather, collate and provide this data to others, but also for those other organisations that wish to use that data. And I do think GDPR makes it very, very much more clear than at present that any organisation that is using personal data has absolutely got to make sure that they have confidence and evidence that the data that they are going to use has been gathered fairly and lawfully and in accordance with the laws. And that, I think, is where the challenge comes. And I think what we have in the third-party data space is there are a lot of chains. So we have people who gather data, but they in turn pass it on to someone else who is an aggregator, and they in turn may work with other organisations who provide it to the end users. So it's quite a complex chain, and actually the issue is the end user must be wholly confident of the origin of the data, and that, I think, is where some of the complexity comes.
Although it seems to me to be just the right thing to do, which I suppose is the case a lot with GDPR, isn't it? It's almost like getting back to basics and forcing people to do the right thing, or am I being vastly oversimplifying, really?
No, and for a long time now, the more that I've looked at GDPR, I kind of agree with what you said. I mean, if you tried to explain to somebody that what you were going to do is you were going to collect their personal information, various bits of information, and then just sell it on to anybody that wanted to buy it because you had ticked a box saying you didn't mind third parties using it, and then those third parties were going to do all kinds of different things with it and maybe pass it on to other aggregators that were going to use bits of it or maybe not, just all of it, and then other people might be getting in touch. You couldn't really honestly say that was in any way an informed use of anybody's data. They weren't giving explicit consent. It wasn't clear maybe at the point of sign up, and that's what people have been saying for a long time now. I remember when the charities got into trouble a couple of years ago, the one phrase that kept coming back again and again was that people had lost control of their data. And I think that's what has happened with third-party data in the past and what GDPR will hopefully put right.
I mean, let's just take a step back. I mean, it's quite late in the day, but if you were advising or talking to somebody about what they need to do and they're very much at the beginning of their journey, I mean, what what's the first thing that people should think about in terms of their third-party relationships and that third-party data?
If you're a company that's buying third-party data, you just have to be very careful about where it came from. Exactly as Fidelma just explained, you have to have you have to do an amount of due diligence that would give you confidence that the person selling that data knew where it had come from, and they could demonstrate how the person had agreed to receive this marketing from a third party, and that it wasn't collected 5 years ago, and all those kinds of things. So I think there's a lot of work for the users of third party to do, and there won't be nearly as much data around that passes those tests. So I think there's going to be very much a change from quantity to quality of third-party data.
Okay. And Fidelma, if you were sat opposite somebody explaining how GDPR classes third party, and also what they might need to do to make sure that they're not in contravention to anything that GDPR is going to outlaw, for want of a better way of putting it, what would you say to them?
I would actually encourage them to read the ICO's enforcement notices on the charities.
Okay.
Because it's a really, really good articulation of where it went wrong.
Yeah.
And the charities were using third-party data for two purposes, which John sort of referred to obliquely there. So one, they were using third-party data to fill in gaps. Yeah. And secondly, they were also using third-party data to apply attributes to individuals. So we've all heard of the wealth indicators that were used. So it's not only that people are buying full sale marketing lists, so a list of people to whom they can direct an email or a piece of do telephone marketing. It is about filling gaps in their own that will be impacted, and this issue of overlay of third-party data. And I think one of the things you sort of touched on it yourself, Russell, is that moving away from the heart of GDPR. And I think it's worth remembering there are two real key words for GDPR. One is transparency. GDPR has been brought about because the individual in a data age was not truly respected or reflected in the laws and how it was operating, exactly as John has said. And secondly is the word accountability. Organisations that are using personal data need to be able to evidence that they've thought it through, and that they have thought it through with the individual at the heart of that decision-making process.
We have talked previously on previous webinars about legitimate interest. Is there a line to be drawn between legitimate interest and third party, in the sense, is that a defence? Sorry, using a more positive word, a justification?
Yes. It certainly is a possibility. I think, I'm sure actually, that in the recital that refers to legitimate interest, it does talk about third-party usage. But I must admit, when it comes to the subject of third-party, does seem to be a sort of a slight hole in the guidance. We've got guidance for just about everything else now. Right? If you want to know about consent, you can find out about consent. If you want to know about legitimate interest, you can do that. If you want to know about all kinds of, profiling or whatever it is, there's guidance and things like that. But when it comes to the subject of third-party data, which isn't a specific topic within GDPR, it's kind of like a combination of different things. There isn't really any solid guidance, and which is something that the DMA is working on with a group at the moment, and I'm really hoping to be able to bring something out that people can look at. But it's at the stage now where some companies have decided that third-party data can be traded using legitimate interest, and there are a number of big data companies that are doing that. And then there are one or two that have kind of looked at the same bits of law and the same evidence and gone the other way and said, well, no, we don't think we can use legitimate interest in that way. And right at this moment, there's no way of telling who's right or who's wrong. Maybe the people who've decided to sit it out for now are just being a little bit overcautious, Maybe the ones that are, are going ahead, might have it completely right, and everybody else will follow suit quite quickly. But I think this is possibly one of the areas that people are treating the most cautiously.
Thanks for that, John. Before we just move away, there are questions coming in about third party, but I'll just park those and we'll come to them at the end. But before we move away, or I move away in my questioning, John, just wanted to just see what any, if any, learnings there were from the recent case involving Facebook, Cambridge Analytica, whether or not there was something, an implication there when it comes to third parties, something for people to consider, apart from just don't do the same thing. Well, don't get yourself on the front page.
And obviously it's difficult to comment on the Facebook Cambridge Analytica.
No, I'm not asking you specifically.
No. It's just that I think that's quite a specific case, and the ICO are looking into that, and who knows what was going on there. But I think generally with Facebook, I think what you can see is that certainly Zuckerberg, since he's been questioned in the States, has made a lot of changes in exactly the direction that Fidelma was just talking about transparency. It's quite clear that people didn't really understand what was going on. And now it might have been spelled out to them in privacy policies and technical documentation along with certain apps and that kind of thing, but they obviously didn't read that, and who the hell does? It's like 60 pages of dense text. Nobody's going to go through all of that privacy policy just to download an app. They just go ahead and do it. So all of the changes that have been made and everything that has been talked about has all been about the consumer being made aware in a more fair way, which just goes to the whole thing about transparency and accountability.
Thank you very much. I am just going to just pose a couple of these questions that are on related subjects and see whether or not there's something that you can help these people with. Jonathan has asked, what happens when my client has an email database that they have gathered over time and are unsure where it derived from? What does Jonathan or perhaps his client have to think about there, would you say?
Well, I'm assuming this is consumers and not B2b.
It doesn't specify either way. But
and if you've got the email addresses of consumers but you really don't know where they came from, or you can't point to the date and time that they opted in to receive your communications, if one was being particularly strict with the law, you'd say that you don't really have permission to email that data now, let alone under GDPR. You've always really had to show, some history. If so anybody asked where a company obtained their data, you'd have to be able to give them some information. You couldn't just say, well, it's on our database. GDPR is quite specific about the fact that you have to document consent if it's consent that's being used, and you have to know where and when it was captured and what privacy policy was in place at the time, all of those kind of things. So if I had a lot of data that I really didn't know where it came from, or whether people had opted in, or whether it was a soft opt-in, or whether I just got the email address from who knows where, it doesn't come up to the standard of GDPR consent. So you couldn't use consent to communicate with that data after May 25th, and possibly even now. So you might need to think of another way of re-engaging that information. And some people have gone out with direct mail campaigns to try and get those people back on board.
Yeah. Reconsent communication campaigns. Fidelma, have you got anything to add to that?
Just in the context of reconsenting, again, it's worth looking at some of the enforcement notices, because we have seen a number of organisations that have chosen on the back of GDPR to go out to people who've previously said no, to see if they sort of like to change their mind, or they could regather the consent. But the process of that engagement is itself considered to be marketing. So there is an area there where people do need to be cautious that even with the best intent, it is sometimes not actually permissible.
Yeah.
You can't break one law to try and comply with another. The ICO said, I think, which is a
that seems to me, I'm no legal expert, but that seems to me like good, solid advice. And then the cases are all available via the ICO website?
Absolutely. They have a very, very easily searchable area on their website for their enforcement notices, and we will on the 25th of May be publishing our annual enforcement tracker, which people can look for online.
There you go. You got your nice plug in there for Dama. Well done. This is a very long question, but it seems to me to be entirely relevant around third party, so I'm going to read it. This is from Joe. As a B2B customer acquisition company, brackets lead gen, how much of the regulation applies to business information? We're using contract as our legal basis, so people complete our form and we will get 4 suppliers who meet their requirements to contact them. We're transparent about what we do and how we operate, but the water here is a bit murky, i.e. information available online, brackets such as company phone numbers. If we get a wrong number supplied, are we able to collect that to fulfill our services? So it's a specific problem, but it seems to me to be one that perhaps universally could be an issue. Sorry, that was a very lengthy question stroke case study that Joe gave us, but any immediate thoughts, guys?
Well,
go ahead.
I'll just because I'm not from how maybe it was the way you read it out, Russell. I didn't maybe I didn't get the full story, but B2B is a little bit different when it comes to email, because B2B
let's focus on that first.
B2B under the current regulations and post GDPR will not require prior consent in order to contact those businesses by email or SMS. So when it comes to electronic marketing, you don't need to have prior consent. So that's not actually a GDPR requirement. That's under PECA, or the Privacy and Electronic Communications regulations. So companies can just pretty much go about collecting B2B data and making contact with it. You have the pure cold emails that we all receive in a B2B sense every day. That's perfectly legit. You just need to make sure that it's likely that the person receiving it's relevant to them, and you need to provide an unsubscribe.
Dama?
I would think from an organisation's perspective, I would always say think about the individual receiving it. So again, for me, the building of, if you like, prospect lists and blind targeting doesn't play well, whether it's in B2B or B2C, but that didn't sound like it was that environment. So this sounds like, if I understood the question right, that it is someone looking for guidance about where to go. So I'm not quite sure. So if it is in response to an individual wanting something, then that could be, fine. But if people are using other organisations' data to generate their own business model, then there may be other implications.
Well, seeing as Joe's not here to respond,
yes.
But what I'm pretty confident, even if it wasn't an answer to Joe's question, it was an answer to somebody's, because that seems like perfectly reasonable and very valuable advice.
The B2B thing has come up a few times, and there's a number of articles on the DMA website that I would direct somebody to. Anybody can access those.
That, again, is a great resource, and it doesn't begin or end today, obviously. There are resources from these guys and also the ICO that everybody listening can look at afterwards. Now, I'm going to just move on, because we've already got questions around privacy notices, and one from Margot I'm going to actually begin with, which is, what do you mean by a privacy notice? In terms of in the context of GDPR, what is a privacy notice? Selma, do you want to go first?
Grand. Basically, the privacy notice is the means by which you inform the individual about what you will do with the data they are providing. You will be clear with them who that information will be shared with, what purposes it will be used for, how long it will be kept, and basically how they can exercise their rights in the context of that data. So the GDPR changes the requirements for these to a certain degree from the privacy notices we will see now in the context of the Data Protection Act. there will need to be a provision to individuals of access to the details of your data protection officer if one has been appointed under the law. And I'm sure I've forgotten something, John. So
well, the thing that I always try and tell people with privacy notices is that in the past, privacy notices were a one-size-fits-all. Every website has a privacy notice or a privacy policy or a privacy promise. People call them all kinds of different things. Every website has one at the bottom of their page, and as Fidelma said, it tells you what happens with your information. In the past, you used to be able to just download a template from the web, find and replace the company name, and you had a fully compliant privacy notice. But that's not the case anymore. They're quite specific to each individual company. So you have to know what goes on in the company to know what to put into the privacy policy. And as Fidelma said, all the sort of relevant information about what happens with your data needs to be talked about. Who the data controller is, whether you're going to use it for marketing purposes, whether you're going to be doing any profiling, all that kind of thing. And you have to make it easy to read as well. So as a lot of GDPR has been a bit of a culture shift, because before data protection and data was all about the company, and now GDPR flips that on its head and it's now all about the consumer. So you have to write this in a way that it's meaningful to a consumer, not in a way that protects the organisation.
So it's a job of sharing, it's a job of transparency, which underpins GDPR generally, and obviously the accountability, because you're going to be held accountable for what you say. But it's also a job of communication, it seems to me. So, I mean, but again, going back to a point I made earlier, it seems to me to have been standard or good practice to make all of this information palatable, if I can speak, to customers. Why would you make it all legalese and difficult to read?
Russell, I think you've hit the nail on the head. For me, I think people have not actually spotted the opportunity that there is for brand value in a well-written privacy notice. If you think about the experience that you have in visiting a website or signing up for a loyalty card, if it is actually written in a tone of voice that reflects the brand values of the organisation, you feel that much more, actually respected and more likely, if it's written in accessible terms, clearly laid out, and you know what they are going to do, you feel much more confident and comfortable. So I think it's for marketers particularly, it's nearly a missed opportunity.
Is there an opportunity for people, in line with their brand's tone of voice generally, to be playful? I mean, this is serious stuff, but at the same time, do we have to be all po-faced about it?
I've literally just come from a presentation about compliance and creativity. And
that's an oxymoron, surely.
And the subject of privacy policies came up because there's a lot of information to get across, and like we said, you've got to be able to present it to people in a way that's meaningful to them. And there's a number of companies that have done some unusual things with this. Some companies do what's recommended in most guidance and do what's called a layered privacy policy. So you talk about the subjects in a couple of sentences, very, very clear, and then there'll be like an expand button, so you can expand out into the legal details. But some of the best ones that I've seen are actually, they go one step further than that, and they present the information, what's going to happen with somebody's data, in the form of a video. And there were a couple of examples that have been knocking around on this for a while. There was The Guardian, they did one, and Channel 4. But now EasyJet have done one as well. And the EasyJet one's really nice, and it's done in a very creative way, just like an in-flight, the in-flight safety announcement. So it asks you to take a couple of minutes to listen to their announcement about what's happening with your data. And as Fidelma said, it's a great way of engendering trust. It's a nice way, you don't have to read all the text. You can watch that, 60-second, 90-second video, and get a really good idea about what's likely to happen, and more importantly, what's not going to happen with your data.
One of the other things that some people may be aware of is that on the 9th of April at their annual conference, the ICO made the announcement about their UK consumer education program that is coming called Your Data Matters. And the objective and the driving force behind that is the ICO's desire to increase the degree to which UK consumers have trust in organisations using their data. But the way they approached it was through a consortium of organisations which the DMA has been on and which I've been supporting, so that actually the view from across a range of industries and engagements with individuals could be taken on board. And there will be very soon on the ICO website a release of some of the materials for everybody to see. The campaign is coming out under the banner of Your Data Matters.
Right.
It's very much focused on the individual, but it tries to set out some of the positive elements of sharing data as well as making people aware of their rights. And the GDPR itself isn't like in the headlines on anything, but it is just about this overall awareness so that the UK population actually has that baseline understanding, and then brands can layer on top of that their own brand persona.
Thank you for that. We've got a lot of questions in, but they're all, well, they touch upon lots of different areas, some of which we've touched upon in previous webinars. So I'm going to go through those in as much detail as I possibly can in a moment, but I just want to get your takes on what people can do at this relatively late stage. Is there a checklist, a tick list that they need to make sure that they've considered, done, start doing if they haven't already, a final checklist that we can perhaps build for people over the next, well, what is it, just over a month now?
Well, yeah, there is exactly that. There are a couple of checklists out there that people can use. The ICO has a good one. They have a 12-step guide, which always reminds me of the Alcoholics Anonymous 12 steps, but I'm sure it's nothing to do with that.
It might drive people to drink.
There's also a number of checklists on the DMA website. There's a good one about just checking through, it's a checklist to make sure that everything you're doing is GDPR compliant in the way that you're collecting and using data. So, you could go through that at any stage and highlight the bits that you're doing well and the ones that need a little bit more work. And I think there's a couple of others elsewhere as well which you can seek out. But I think the 12-step guide from the ICO would be a good start.
Yeah.
Thank you.
And I think also people should be able to access details from the ICO's conference that I mentioned earlier. And this question was asked of Elizabeth Denham at the end of the conference. What she absolutely emphasised that she would be expecting people to see is those privacy notices written, so that individuals actually understand what organisations who have their data are doing with it and how they can exercise their rights with them. So I think she is hugely and wholly focused on that element. The other thing that isn't actually on the ICO's list per se, but is something I would encourage people to do, particularly in the context of controller-processor relationships, is look at your contractual obligations, the contracts that you have in place with people who are processing data on your behalf, or if you're a processor where you are processing data on their behalf. Article 28 of the GDPR addresses specifically what now needs to be included in contractual provisions for GDPR. So it is something that I would encourage people to look at, because most organisations have a huge number of contracts in place. And quite often it's not the changing of the contracts that takes the time, it's actually locating the most up-to-date version of the contract and making sure that they have identified them all and that they know where data is flowing to, which ties back to the point 2 on the ICO's own checklist, which is understand the data you hold and understand where it is flowing to.
That's a good one, because doing a data audit or data mapping is a good starting place for understanding. And every time I've spoken to anybody about that process, they've always uncovered something that they didn't know was going on. There'll always be a department in the company that has got its own third-party arrangement, with another supplier, and data's flowing backwards and forwards, and the IT people or the management team didn't know about it. It was just something they set up on their own. So it's an excellent way of getting your house in order, if nothing else.
I couldn't agree more. And one of the other things as well is that so many contracts, when they are drawn up, are owned by someone who really gets engaged and everything, and they've stored the contract details actually on their own machine, and then they've left, and then you have of data flowing out of the organisation, and that somebody is doing something with it, but
you don't know what.
And John, one of the things I was thinking about that we didn't touch on in the privacy notices piece was we spoke very much about the outwardly facing privacy notice, but of course organisations need to make sure that they are treating their employee data in accordance with the provisions of GDPR. So this isn't just about your customers, everything, all personal data that you deal with.
It's something I often forget, actually. GDPR it wasn't made up just to make marketing lives difficult. It's actually for anybody that deals with data. It's not just us. But of course, I'm always focused on just looking at it through marketing eyes.
Through marketing. And the other bit for the privacy notices that I think I missed off in sort of running through is, of course, this issue of cross-border transfers. You do need to both understand and inform individuals if data is being transferred outside the EEA to other countries. So that becomes an important issue.
Thank you guys for that. For everybody that's listening, and specifically for those that have asked questions and posed questions, I've just got a technical error, so I can't actually see those questions at the moment, but we are working on it, and I will still try and get through as many of those as I possibly can before we finish. So I'm just going to continue with my own questions for the time being. On May the 25th, the journey, I suppose, doesn't end there, presumably, even for those that are very confident that they've done everything that they need to do. Is there something that people need to continue to think about? Is it about continuous improvement? Is it about iteration? Is there other things that they need to think about and look out for once that deadline comes around on the 25th of May?
GDPR isn't just a one-off thing. It's not like passing your driving test. It's done and you never have to think about it again. It's very much an ongoing process. So every time you do anything that involves personal information or personal data in the future, you will have to handle that in accordance with GDPR. And all the new processes that you bring in, new marketing campaigns that you do, you'll be thinking about GDPR. And even over the next 12 months, guidance might get updated. We might see some enforcement action that changes people's opinions on certain processes. I think this is going to be very much a change, an evolution of how people are dealing with their information. Because at the moment we're starting from a place of, we've got the law, we've got the guidance, and everybody's doing things, their own way. And I think there'll be a lot of learning and bedding in before things are finally settled.
Delma, any thoughts on post 25th of May?
Yeah, I heard a very good analogy the other day, and I think it's worth sharing. Where we are now is like getting ready for a West End play. We are in the rehearsal and we go live on the 25th of May, but it's going to be the longest running West End play in Christendom, and there will be changes like you have in the actors in the play. There will be new things coming in, and maybe it's a bit closer to that company that literally make up the musical as you are there. So it is continually evolving. But what John was saying about this is the beginning of an ongoing evolution of the process. And we will see what happens across Europe. Of course, we have the issue, dare I mention the word of Brexit. We have our own data protection bill. And of course, from a marketing perspective, we are now waiting to see what will happen in the context of the revised e-privacy laws. And, you can't help but wonder now, is that going to get closer scrutiny with some of the things that have happened recently? So I think anybody who thinks the 25th of May is the end, I think they've slightly missed the point. Yeah, 25th of May is the beginning. Yeah.
So it's the end of the beginning now. Is that right? Yeah. Anyway,
not the
end of the rehearsal.
Don't sit back. Yeah, don't sit back and think job done. Come 25th of May.
Yeah, absolutely. And I think one of the things that we've seen, and that I definitely get the feeling that the Information Commissioner is comfortable about, is that everybody may not have finished their journey. But as long as you are on that journey and you can show through what I would describe as an accountability Bible, that you can actually evidence that you're on the journey, and that evolving journey, and that you've considered the choices you have made and you have a plan for the things you've yet to do. That is what will stand you in best stead. The regulator, again, they have been very clear that if you've made a choice which is clearly evidence and that has had thought that has gone into it, they're not going to slap you around. What they may do is say, well, look, we don't agree and we'd like you to change it, but evidence of clear thought process, and again, that thought process that is focused on what is at the heart of the individual, at the heart of the GDPR, the individual.
Thank you both for those 25th or post-25th of May thoughts. We've got our questions back, and thank you very much for everybody who has posed. We've had lots and lots of questions, so I'm going to spend about 15 minutes going through some of those. Now, a recurring theme is something that, John, you've already touched upon, and a lot of people are asking, what about B2B, effectively? That's what they're asking. They're also asking, what's the difference between B2B and B2c? So I'm not going to go through every single question because everybody's got their own specific circumstances, but it seems to me that there is still a little bit of confusion amongst B2B marketers and people in B2B businesses as to what does apply to them, and indeed how that is different perhaps than their counterparts in B2C. Now that's a big question, but if we can start to unpick specifics around B2B and specific requirements around B2B.
Yeah, well, hopefully I should be able to sum this up relatively simply.
Excellent.
GDPR talks about personal data, and it doesn't matter where that is. It doesn't make any distinction between B2B or B2C, and it doesn't talk about different channels and that kind of thing. It just talks about how you should treat personal data. So business-to-business data is still personal data. Okay, so my email address, john.mitchison@dma.org.uk, is it's a business email address, but it's personal data because it identifies me as an individual. Similarly, my personal email address, john.mitchison@yahoo.com, that's personal, but it's not business. So as far as GDPR is concerned, all the same things apply. If you're collecting B2B data, you still have to have an up-to-date privacy notice. You still have to be clear if you're gathering that data with consent. Where the changes are, where the differences between B2B and B2C lie, are in the PECA regulations, PECR, or the e-privacy regs.
Right.
And it's there that B2B gets this little get out, where it says that you don't need prior consent to send emails to B2B, in B2B context. Whereas you do need consent if you're sending business to consumers. So we all know this, right? You don't get spam from just everybody in your personal email box. You have to give consent to companies, and then they can send you marketing emails. But in a business sense, we probably see this every day. You get emails come to you from other business organisations. Now, as long as they're relevant marketing that's being sent, and there's an unsubscribe on it, that's no problem. Okay, so that's where the main difference is. And actually, that's probably about it, because when it comes to other forms of marketing, if you're looking at the traditional marketing channels, you can use an opt-out basis there. You don't need prior consent in the B2C or the B2B space.
So the answer kind of is it's the same, but maybe different in some respects when it comes to B2B.
Just when it comes to email, yeah, it's exactly the same, except you don't need prior consent for email or SMS.
Okay.
In a sentence.
Phil, you work for a B2B organisation, so you're coming at this firsthand. I mean, your take on the differences and particular requirements of a B2B organisation?
Yeah, I think as John has said, and one of the questions that is most frequently asked under B2B that I have heard is, if I meet someone and they give me their business card, what can I do with it? And it is interesting because specifically on the ICO website they do call out that a loose business card in itself is fine. It is the process of putting that data onto your organization's CRM or marketing database and then potentially making it accessible to others, and then the process of using it. That organizations do need to think that process through and be comfortable with the processes that they have defined and, the individual whose name has now been added to the database. So I think this is an area where we will see quite a bit of evolution. And many years ago, when the Data Protection Act first came out, I did know of one lawyer who had printed on the back of his card, "By giving you my card, I am happy for you to put my name on your database." Because he said it was one of those gaps. And it's interesting now to see it's come straight through.
We're talking about adding personality to your...
Yes.
That's one way of doing it.
That's definitely.
Thank you for that. A question here that I think is interesting. It speaks about smaller organisations, and it also speaks to some of the points that we were talking about what people can do in the final few weeks, and indeed what a post 25th of May landscape looks like. So I'm going to ask it in its entirety. A lot of smaller organisations with less capacity are struggling to get everything ready for the 25th of May date when legislation goes into the law. I've heard that with regards to the 20th of May cut-off date, as long as we show we have a clear plan and timeline for compliance, we don't have to be 100% compliant. Is that correct? Now, you guys don't work for the ICO, but are you getting a sense from what you've heard from them that a plan, an intention, a principle or principles in place is going to be enough, or is it, you're either in or you're out, you're either right or you're wrong?
No, I think that person's pretty much on the button with that. I mean, as long as you're working towards it, maybe you've missed the 25th date, but it's unlikely that that's going to cause you a massive problem, unless what you're doing is generating a load of complaints. It's unlikely.
And you're probably doing a lot wrong with the current regulation, might you?
So just keep going, and you might never stop. There might always be something that you're reassessing or deciding to do slightly differently, or you're updating your privacy notice. I think it's something that we'll always be working on.
Absolutely. And what I would also suggest is organisations will find, I think, this easier if they don't simply think about it as a compliance exercise. I think if they really embrace the fact that this is something now that is here to stay and it's centred on individuals like everybody listening today. So they all want organisations to treat their data well, and I don't know about those who are listening today, but I have certainly started to get a lot of communications from people telling me that the privacy laws have changed and what that organisation is seeking to do about that. So it is not simply, this is a real opportunity to get your house in order. And what I would add to the thing about, no, I don't think the ICO expects everybody to be absolutely with a clear tick box against everything they want to get done by 25th of May, but neither should that be a reason for putting off getting the things done. Because that won't sit well. And should something untoward happen, which can happen, is you need to be prepared to provide that evidence to the regulator.
Thank you very much for that. We've still got a little bit of time, so I'm just going to plough on through a couple more of our questions, and thanks very much to everybody who has posed them. It's much appreciated. It's again quite a lengthy question, and we've had lots of those. I do appreciate you taking the time to engage with us on GDPR. This question sort of sums up quite a few, so I'm going to ask it in its entirety. If we've collected prospect data from various third parties throughout the years, building up our database as a result, do we need to ask them to opt-in / give consent for any future marketing, or is it enough to let them know that our privacy policies have changed and they can opt out if they wanted to? It seems like there is not an exact answer. Now that speaks to pretty much everything that we've spoken about so far today, but I thought it was a nice summary question.
There are very few exact answers when it comes to GDPR, and in a way that's a good thing, right? Because it's not prescriptive. It doesn't tell you exactly what you can and can't do. It's a principles-based legislation, so you get to be flexible and make your own decisions. If you've got a database, it said it had been developed over time from various third-party sources. Well, I presume you haven't just bought third-party data and put it on a database. You've been communicating with that data. As long as you can justify a legal reason for continuing to communicate, there's no reason why you can't keep doing that. But how you do it may depend on a number of other factors. So if those people have given you consent and you're able to demonstrate that consent, for want of a better word, ticks the boxes of being, transparent, clear, documented, and all the other bits and pieces, then you can continue using it. If you can't, then you might need to consider another route. But it does very much depend on how the data was collected and what was told to the people at the time and how they've been communicated with over the past years. And I kind of got the impression from the question that might be B2b, so there might be some differences there as well. If I had more information, I could give you a solid answer on that, but it's a little bit vague, I think.
Yeah.
It's fine. I'm sure that the questioner got plenty from that, and indeed everybody else listening. The questions that we've got are brilliant, thank you. We're not going to get through them all today, and we are indeed reaching the end of our time. But there are lots of resources out there. We've mentioned some of them today, the work that the DMA has been doing, and indeed PwC and the ICO. Is there anything else out there that you would recommend, any not offered by yourself, that you would recommend that people go to, any tools and tricks? Because there's a whole wealth and a whole wealth of information out there, but is there anything at all that you would recommend?
My first port of call, if it's not on the DMA website, is the ICO.
Yeah.
The ICO enforce this legislation. They're the ones that they're not making the rules, but they're closest to it. There are some other organisations like the ASA, but I'm not sure if they have a huge amount on GDPR. They're a little bit more general.
The other place that I have found helpful, because they are natural English-speaking country in the EEA, is the Irish Commissioner's website. And it's quite helpful to go in and have a look, because of course the GDPR is a harmonised law across Europe. So that's another place that I have been for just a look again, just to see if there's anything additional.
Okay.
Yeah.
There's plenty out there is the message.
Yes.
I'm going to conclude, bizarrely, because a few people have asked it, with a question that isn't actually about GDPR. It's about the Privacy Directive, which I know one of you mentioned earlier. Now, this is another headache stroke opportunity that everybody has to think about. Tell me about what the developments are there and what impact and what considerations people need to think about.
Okay. Well, the e-privacy regulations, we have e-privacy regulations now in the form of PECA. They're being updated, and they sort of sit alongside the GDPR or the Data Protection Act. So you have to kind of use both bits of legislation. So for a while we're going to have the new GDPR working with the old PECA regs, and there's a little bit of a mismatch there, but I'm sure we'll sort of muddle through. But probably around the end of the year we'll have the final text for the new e-privacy regulations, and they cover electronic marketing. So the specifics around email, SMS, but also cookies and other things like that will be covered in that regulation. Now, at the moment, I'm reluctant to say a great deal on it because it's still making its way through the European lawmaking process, and each of the main points of issue, of contention, kind of could go either way. So in a worst case scenario, they're going to insist that you have consent for everything. So that would be consent for B2b emails, consent for B2c emails, consent for every cookie that you put on somebody's website. In a much more reasonable outcome, we would have the option of consent and legitimate interest, and it would be much more following the status quo as we have now. But I'm not very good at predicting these things. I got the American election wrong. I got Brexit wrong.
You weren't the only one.
I'm not going to put any money.
Don't do yourself a disservice.
On which way this one comes out, but it's one to watch because there's been a few drafts and they've been a bit all over the place, really.
Yeah. Fidelma, any quick thoughts on e-privacy?
So that's great, and the place I would go to keep up to date on that is both the ICO's and the DMA website, because they keep a very close watch and actually actively contribute to the debate on behalf of the industry, so that's great. What I would say, though, to marketers now is that do not forget the PECA rules in the context of what you are doing on GDPR, particularly if you are looking at marketing online, particularly where you're using both first and third party cookies, and also if you're doing any in-app marketing. Just do consider all of those areas in the context of GDPR. It is, yes, we are waiting for PECA to land, but if you are using personal data to deliver personalised or relevant messages to an individual, then the GDPR will apply, regardless of if it is a digital or non-digital channel.
Thank you very much. Thank you, Fidelma. Thank you, John. I'm just going to read out an observation. It wasn't even a question. No wonder a lot of SMEs are finding this subject so difficult to understand. Exclamation mark. That's not. I don't make that point to cast aspersions on you two, but just to make a final point. It seems to me throughout the 3 GDPR webinars that we've completed that the overriding message coming from everybody who's contributed has been, think of this as an opportunity. Yeah. Think of this as an opportunity to be more transparent, have that more transparent relationship with your consumers, with your customers, and think of it as an opportunity to, I suppose, start again, and to clear the decks, I suppose, is another way of putting it. It's not the end, it's the 25th of May, it's just the beginning. Now, as a journalist, it's easy for me to be very utopian about this. I appreciate that for everybody out there listening, it might be a bit more of a pain in the arse. But remember, this is an opportunity, it's not just that pain in the arse, it seems to me. Thank you, as I say, for everybody that listened today. You can listen again to this webinar and you'll be emailed, everybody who registered today will be emailed with the link to be able to listen to that again. And you can hear more about about GDPR and read more about it on marketingweek.com, where we will continue our coverage up until and indeed after the 25th of May. Thanks to everybody for listening today.